Is solitary confinement constitutional? Eighth Amendment explained. Imagine being locked away in a small room 4 hours on end, with little to no human contact. This is the reality for many individuals in solitary confinement. But is this practice constitutional under the Eighth Amendment? Let's break it down. The Eighth Amendment of the United States Constitution prohibits cruel and unusual punishments. This means that any punishment must not be excessively harsh or inhumane. Solitary confinement typically involves isolating a prisoner for 22 to 24 hours a day. The conditions can be quite severe, leading to questions about whether this practice violates the Eighth Amendment. When courts evaluate claims related to solitary confinement, they often use a two-part test. First, they look at whether the punishment is objectively harmful or excessive. Second, they assess if prison officials were deliberately indifferent to the inmate's health or safety. This means that if the conditions of solitary confinement are harmful and officials ignore these effects, it may be deemed unconstitutional. Currently, there is a divide among federal courts regarding the constitutionality of solitary confinement. Some courts argue that prolonged or unnecessary solitary confinement can indeed violate the Eighth Amendment, especially if it leads to serious mental or physical harm. On the other hand, some courts maintain that solitary confinement does not violate the Eighth Amendment, regardless of duration or effects. The United States Supreme Court has not provided a clear ruling on this matter, leaving it open for interpretation. This uncertainty creates a complex legal landscape for those affected by solitary confinement. Specific groups, such as juveniles and individuals with mental health issues, are often seen as more vulnerable to the harms of solitary confinement. Legal scholars and courts argue that isolating these populations can be particularly cruel and unusual. Some advocates even call for a complete ban on solitary confinement for juveniles due to the severe psychological impacts it can have. The length of time spent in solitary confinement is also a significant factor. Many experts suggest that confinement lasting more than 15 consecutive days could be viewed as potentially unconstitutional. The evolving standards of decency in society and the original understanding of the Eighth Amendment play a role in how courts interpret these cases. For anyone facing solitary confinement or knowing someone who is, it is important to understand your rights. If the confinement seems excessive or harmful, there may be grounds to challenge it as unconstitutional. Legal challenges often requiring showing that prison officials ignored the harmful effects of solitary confinement. Additionally, state constitutions may provide further protections beyond the federal Eighth Amendment. Some states include rights to safe and humane treatment, which can be used to contest solitary confinement practices. In summary, while solitary confinement is not automatically unconstitutional under the Eighth Amendment, its prolonged or harmful use, especially against vulnerable individuals, can violate the prohibition on cruel and unusual punishment. Awareness of these rights is essential for those impacted by solitary confinement.